Well, tonight we are piecing together new details in the trial of Ryan Routh. Now, Routh was found guilty of attempting to assassinate then presidential candidate Donald Trump at his West Palm Beach golf course last year. Now, he faces life in prison when he is sentenced in December. Now, Tuesday's verdict took a dramatic turn as Routh attempted to stab himself in the neck with a pen. Now, court sketches show that moment as U.S. Marshals grabbed him and took him away. Now, Routh, who defended himself, rested his case Monday morning after questioning just 3 witnesses in less than 3 hours. Our news team dug deeper into his defense and expected hundreds of exhibits, and the 59-year-old wanted to show the jury, but never got the chance. Now, WPTV's Ethan Stein shows us the evidence and asks an expert if Routh should have been representing himself in the first place.
These are some of the hundreds of exhibits Ryan Routh wanted to present to the jury, acting as his own attorney. None were allowed.
From an autobiography to various photos and even a letter to the leaders of North Korea, Ryan Routh had plenty of evidence to show the jury. Court records we found show he proposed presenting hundreds of pieces of evidence.
You can't just throw evidence in.
We showed some of these exhibits to attorney Michelle Suskauer. She says these pieces of evidence were presented beyond the discovery deadline and irrelevant to the case.
He is not familiar with the rules of federal criminal procedure, and he's not an experienced attorney. So that is certainly a detriment to him.
Judge Eileen Cannon allowed Routh to represent himself after a hearing. In the order, she explained the Sixth Amendment provides a criminal defendant with a corresponding right to self-representation. Judge Cannon also wrote the forensic evaluation referenced defendants' mixed personality features, and any such personality features do not impede in a defendant's ability to knowingly and voluntarily waive his right to counsel. Suskauer says a judge can reverse the decision during a trial if there's disruptive conduct.
You may have to re-question if something goes south.
Cannon repeatedly reprimanded Routh to follow the rules of evidence during trial and asked questions about his ability to follow the rules. But Routh's misunderstanding of the law led to his opening statements being cut short, sudden calls for impromptu breaks, and Routh being intimidated to object or challenge the government.
There is no guarantee that a lawyer could have helped Routh get acquitted on any of the charges, but it's worth noting Routh had no evidence of his own to present the jury, and most of his witnesses were not allowed to testify, being ruled irrelevant to the actual case itself. In West Palm Beach, Ethan Stein, WPTV News.